Yes, I salute you all. Thanks for listening and thanks for watching. So basically today we are under family law 2, and the topic of emphasis that we are going to look at, we are under the law of succession. And today we are going to look at the law of succession. And in this essence, what we are going to look at, we are going to look at domicile. As in under family law 1, we saw what domicile means. And I won't go to details because under family law 1 we saw how a person gets what domicile. But under in the law of succession, what we are going to look at, we are going to look at how is its effectiveness on succession. Basically, we all know succession is like it's like inheritance. You get. That's why in this video we're going to look at basically domicile, and another video shall look at types of what succession basically. And in this essence, what you have to know, that under domicile under domicile, we realize that domicile, that is your place of residence. But the law and under the Succession Act, when you read section 3, subsection 1, provides the law on immovable properties, whereby here they portray that the law on immovable properties in Uganda of a person deceased is regulated by the law of Uganda wherever that person has had, or wherever that person had his or her domicile at the time of his death. That is for immovable property. And we all know what an immovable property means basically. So note that in mind. And when you go to section 3, subsection 2 of the Succession Act, provides that the law of movable property of a person deceased is regulated by law of the country in which that person had his or her domicile at the time of his or her death. That is for movable property. And I can refer you to the case. When you go read the case of Florence Sally Nudin versus Chamas Charonia and others. That case talks about domicile. You get. Then similarly, when you go to section 3, subsection 3, provides that in cases of intestate succession. Intestate succession, basically that's where the person dies without leaving a will behind. We are going to see it in types of succession in this very video. So intestate succession, that's where a person dies without a will. So section 3, subsection 3 provides that in cases of intestate succession, the deceased is deemed to have his domicile in Uganda once. First of all, when he has lived in Uganda for a period not less than 2 years. By the time preceding to his death. You get. Secondly, where he is survived by a spouse or a child who at the time of his death ordinarily was a resident in Uganda. So basically note that in mind. And basically that is the fee that I can talk about domicile. And what we're going to look at next is the types of succession. And what can I portray here under the types of succession is that we're going to look at the types of succession. There are only two. We have testate succession and intestate. Basically note that in mind, because as a lawyer you must know what is testate succession and what is intestate succession. For testate succession, basically let me start with testate. It is okay. For testate succession, this is where a person dies leaving a will or a valid testamentary disposition. The will must be valid. You get. We shall look at the formalities of a valid will. But the will that is testate, someone dies leaving a will. Unlike intestate succession, a person dies without a valid will or a will. You get. Because you can leave a will, but the will cannot be valid. So the law will presume that you have died intestate. So under testate succession, here basically what we look at is that the will is governed by the provisions in the Succession Act whereby we shall see the formalities of a valid will. And a will actually can be defined as a legal document that states where a property, actually how property must be owned, and how the decedent would like it to be what? Divided after his or her death. There is a case of Lamage versus Goodban. That case defines what a will: an aggregate of a man's testamentary intention so far as they are manifested in writing and duly executed following the what? The statute, basically. And we shall look at the formalities of a will. And similarly, when you go to intestate, where someone dies intestate, that's where letters of administration come. The difference is here. Under testate succession, testate, they provide letters of probate to the successor. Under intestate, they provide letters of what? Administration. That is the difference that I can give. You get to the person that is appointed. So basically, that is a few that I can discuss about the types of succession and domicile. But other than that, thank you for listening and thank you for watching. Stay blessed. Comment where you feel that you want more elaboration. But other than that, thank you for listening and thank you for watching. Stay blessed to the channel. Keep tuned and watch other videos. Thank you very much.